On Wednesday morning, the Montana Supreme Court met before a full audience here in Helena to hear oral arguments in a case that centers on whether the state of Montana did sufficient environmental analysis on NorthWestern Energy's planned Laurel generating station. Last year, a state district judge in Billings vacated a permit for the plant. Environmental groups had challenged the Department of Environmental Quality's decision to grant the permit, saying they hadn't taken a hard look at issues like greenhouse gas emissions and lighting and noise when doing a review.
Plaintiffs here are not criticizing the analysis that DEQ did do. Our point is that there's analysis that DEQ omitted.
During Wednesday's arguments, NorthWestern said greenhouse gases aren't regulated as pollutants, so DEQ doesn't have the authority to regulate them.
The DEQ could not, in the exercise of its lawful authority, deny the permit based on greenhouse gas emissions because there are no legal standards for greenhouse gas emissions.
After the hearing, Northern Plains Resource Council held a rally at the state capitol, saying the impacts the plant's emissions could have need to be taken into account.
Clean and healthful, it's our right!
I asked Mary Fitzpatrick what would have changed if DEQ had taken a closer look at the greenhouse gas emissions.
It's hard to say, and just listening to the arguments, I got the impression that possibly nothing except that we would know. You can't manage or change what you don't measure.
John Hines with NorthWestern says construction on the plant continued while this case is under a stay. He says they've taken steps to address neighbors' noise and lighting concerns, and they've already been testing the plant. He says the plant's generating capacity remains critical to make sure NorthWestern can keep serving customers when other resources aren't available.
The bottom line is we have to have enough electrons and enough gas on our system to meet our customers' needs when it's critical weather. And we saw that in January when it was minus 45. That's our first obligation, and none of the groups who are throwing out alternative proposals have that responsibility.
Now, both sides in this Supreme Court case noted that the issues raised here overlap with those in Held versus Montana, the prominent climate change lawsuit that's also now before the Supreme Court, and that resolving that case could provide more clarity in situations like this. In Helena, Jonathan Amberian, MTN News.